All right, in Chapter 4, we're going to talk about agency law. The chapter objectives are, after reading this chapter, you will know the following: how agency relationship works and the authority that agents have, the function of a sport agent, the duties of agents and principles in the agency relationship, and the many ways in which athlete agents are regulated. This chapter focuses on the law related to agents. We begin with a discussion of the history of the sport agents and the role they serve. Next, we focus on principles of agency law, including establishment of the agency relationship, authority of agents, and the duties agents must uphold. We move to an analysis of agency contracts, followed by an in-depth look at the regulation of player agents. The focus shifts to an analysis of contract law, criminal law, and tort law disputes involving agents. The chapter ends with a discussion of the future of the sport agency. Agency law governs the relationship between a principal client and an agent. A clear historical record can be established related to a player, agent, and this agency relationship. The first well-known player to hire an agent to represent him in contract negotiation was early football star Red Grange. In 1925, Grange hired an agent to negotiate his contract with the NFL's Chicago Bears. Still, the profession did not truly expand until the 1960s, when attorney Mark McCormick began to work with the legendary golfer Arnold Palmer. As the Palmer began to make more money from sponsorship and endorsement deals, athletes from other sports began to seek the representation of player agents. What is an agency? An agency is a consensual relationship in which the agent agrees to act on behalf of another person, the principal. That person also agrees to be represented by the agent. Sports agents assume many roles for their teams, players, coaches, or owners for whom they work. These roles may include the following: negotiating employee contracts, negotiating concession agreements with concessionaires, representing organizations in negotiations with sponsors, advertisers, and media, enter team or organization into events, enter into contracts with entities that run events, conduct estate and financial planning, secure investment and appearance opportunities, and assist in developing online presence or marketing campaigns. The rules of contract formation apply. In an agency relationship, such relationships are consensual, meaning that both parties agree to become part of the relationship. In addition, although agency relationships often are described by contracts between the principal and the agent, such as a student employment agreement stipulating the student will work in a merchandising store for the school, agency relationships also can be created simply by oral agreement. But for any agency relationship to be established by an agreement, both parties must have the legal capacity to be entered into the agreement. Generally, no formality is required to create an agency relationship. This lack of formality can lead to problems which one party disputes the existence of the agency relationship. In evaluating whether an agency relationship has been created, courts typically focus on whether the principal did or said something that the agent could have reasonably interpreted as the principal's intent to allow the agent to act on the principal's behalf. Consider the following hypothetical examples in your book. One is an agent for the Greater Milwaukee Open, and it goes on to talk about Tiger Woods. So let me just explain that one to you. At one event, he happens to stand next to Tiger Woods. The agent stands next to Tiger Woods and introduces himself. Al tells Tiger about the GMO that describes how wonderful the tournament is. Tiger says, "That sounds great. I would love it if you could help me play at that event this year." Tiger is then quickly pulled aside by the media before Al can respond. Al is excited and tells the employers at the GMO that Tiger Woods has agreed to let Al help Tiger play in the GMO. GMO is the Greater Milwaukee Open, by the way. The GMO then leaks the story that Tiger will play in the tournament next year. Ticket and sponsorship sales climbed because of the announcement. In reality, Tiger never intended to play in the GMO because it conflicts with another tournament. 3 weeks after the story is leaked, Tiger's players' agents contacts Al to tell him that Tiger is not committed to playing the GMO. Al disputes that, claiming that he and Tiger had an oral agreement and that Al would act as an agent on his behalf and help him play in the GMO. So eventually, the GMO sues Tiger Woods for lost revenue associated with the loss of sponsorships and return tickets with the media when they learn that he won't be playing. They want their money back. Although Al has a good argument that he relied on Tiger's statement that he wanted Al's help to allow him to play, the court also looks closely at what Tiger said and finds no agency relationship was created. So, to prevent this from happening, let's talk about authority. Actual authority and apparent authority. Okay. An agent acts with actual authority when the agent reasonably believes that her actions are within the scope of authority given to her by the principal. So, to express the authority, an express agency relationship is created when the agent and the principal entered a written or oral agreement. Any written or oral agreement or communication that grants the agent authority to perform an act is considered express authority. Any standard agency contract can establish an express agency that provides the agent with the express authority. Many professional teams, sports, unions mandate that players' agents enter into standard representation agreements with union members before representing any players within the sport. And then there's implied authority. Implied authority refers to the agent's authority and ability to perform incidental acts that are reasonably necessary to accomplish the agent's express responsibilities as provided in the agent agreement. Implied authority must be consistent with the express authority granted within the agency agreement, but implied authority will not be specified within the agreement because unforeseen situations often arise that force the agent to take action for the benefit of the principal. In situations in which it is unclear whether the agent has actual authority, the agent may have what is termed apparent authority. In these situations, because of the behavior of the principal, a third party may believe that the agent is acting with actual authority. As a result, if the principal allows a situation to exist that may mislead others about the actual authority of the agent, apparent authority may exist, and a third party may be able to rely on the agent's actions to hold the principals accountable. Let's talk about the duties. An agency relationship is considered a fiduciary relationship, meaning that the agent has the fiduciary duty to act primarily for the benefit of the player in all matters connected to the agency relationship. In addition, this fiduciary relationship establishes several duties that the agent and the principal must uphold within the relationship. Often the agency agreement specifies the duties that each party has within the agency relationship. Each party, however, owes some general duties to the other. Agents' duties to principals. There is a fiduciary duty that we talked about. Let's go down and talk about fiduciary duties. The agent's primary duty is duty of loyalty. This means that the agent must act solely and completely for the benefit of the principal. An agent is prohibited from competing with the principal in anything related to the subject matter of the agency unless the principal has expressed agreement to allow the agency to compete. And then you also have duty of obedience. The agent is under a duty to follow all reasonable instructions given by the principal, but this duty is not absolute. For example, consider a situation in which an agent represents a motocross athlete. The agent relationship covers all sponsorship and appearance contracts. If the agent and the athlete decide to pool their funds to create a separate company that will design, manufacture, and sell motorcycles, agent's duty of obedience does not extend to the dealings with the athlete within the new company. Principals owe agents a duty to compensate them fairly for the work performed and to reimburse them for all expenses they incur on behalf of the principal. Principals owe agents a duty to compensate them for any losses suffered and to cooperate with agents by not working counter to or interfering with their efforts. The principal also has a duty of good conduct, which means that the principal should not do anything that would demean the agent or damage her reputation. Let's talk about liability contracts. Liability is as follows, and remember, key is whether the agent is within the authority to do this for the principal. So if he is under the authority, then this is the liability. The principal is liable on the contract. Agent is not liable unless agent acts for undisclosed or partially disclosed principal. And if apparent authority exists, principal is liable, and so is the agent, who must reimburse the principal. Liability torts. Under tort law, the principal may be liable when torts are committed during the scope of employment or scope of agency. This type of liability extends to employers under the doctrine of respondent superior. So whether the agent committed as an act resulting in injury to another that was authorized by the principal. The time, the place, and the purpose of the act is important. A court will consider all these factors. Whether the act was commonly performed by employees on behalf of their employers. They're also going to look at whether the employer's interest was enhanced by the act, the extent of involvement of employees' private interests, whether the employer furnished the means by which the injury was inflicted, or whether the employer had reason to know that the employee would perform the act in question. Liability definitions of torts. Respondent superior is a legal doctrine that holds people and organizations high in the chain of command principles liable for the negligent acts of those lower in the chain of command's agents. Negligent acts must fall within the scope of employment, as we've talked about. And scope of employment is the realm of activities engaged in by an agent when acting on behalf of the principal. Regulation of athlete agents. The most scrutinized career for an agent is representation of athletes. The highest profile athlete agents represent athletes in the NFL, NBA, NHL, and MLB. The need for regulation exists because agent has abused this relationship in the past. And all of this has had a negative impact on the athletes. In some cases, athletes have lost lots of money due to the agent's actions. So there are regulation of athlete agents, state laws, and Uniform Athlete Agents Act has been created so to help prevent this abuse. And I mean, obviously we hear a lot about this on social media and different things about agents bankrupting their the principals that they're working for, or all of a sudden they're misusing or mishandling the money. So just so that you know, many states had their own statutes requiring registration and licensing. The UAA, adopted by 40 states and Washington, D.C. states that the main purpose of this act was to provide for uniformity in registration and certification of athlete agents among the states. The act defines student athlete as an individual who engages in, is eligible to engage in, or may be eligible in the future to engage in any intercollegiate sport. For example, this act provides that agents who sign contracts with student athletes must provide notice to the particular university and must make clear to the student athletes that their eligibility is affected. Notice must be given in a contract form. In addition, any agency agreement must include the following language in their contract. You may lose your eligibility to compete as a student athlete in your sport. If you have an athletic director within 72 hours after entering into this contract, both you and your athlete agent must notify your athletic director. And 3, you may cancel this contract within 14 days after signing it. Cancellation of this contract may not reinstate your eligibility. This is actually a really interesting chapter, and if you are considering signing with a professional sport, and I have a lot of those in my class on ground that want to go professional, these are some a really good chapter to read to understand the laws that pertain to this, excuse me. SPARTA was created, the Sports Agency Responsibility and Trust Act. It prevents agents from making false or misleading promises or providing gifts and cash to student athletes and those associated with student athletes. And similar to the Uniform Athlete Agents Act, SPARTA requires written disclosures informing students that they would lose their eligibility to play university sports if they sign an agency contract. Violators face fines, and no registration is required. Then you have the Professional League Union, which also protects each of the major league players. Associated with associations requires agents to register with this appropriate union. And standards vary, but NFLPA has the most stringent. There's annual classes, a passing exam, and how to uphold code of conduct. Given the extension regulation of agents by states, the federal government, and professional sport player unions, it might be surprising to some that agents still run into many problems and end up in court. And there's a couple different court cases listed actually in the book that are pretty interesting. But just so that you know, most of the disputes happen over breaches of contracts or over fraud and misrepresentation. They're really, actually, again, a very good chapter. I know that some of you just watch the PowerPoints and don't actually read, but I found this chapter actually really interesting and informative, especially if you know very little about agents and sports and that type of thing. Just in summary, many relationships in sport can be understood as a relationship between a principal and an agent. Although the most prominent sport agents represent athletes, sport agents also work with sponsors, facilities, events, equipment, manufacturers, merchandisers, ticket sellers, and other entities. An agency relationship can exist any time that one person, remember, or entity, the principal, agrees to have another person or entity work on their behalf. Many agents have engaged in unscrupulous activities when they have avoided their fiduciary duties and acted in their own self-interest or attempted to coerce players to sign with them. With the money involved in sports today, agents are unlikely to stop engaging in this type of contact and conduct. This is why we need all of these laws. All right, that'll be all for this chapter.